What type of family law debts may be discharged in a bankruptcy? In the bankruptcy context, there are two broad categories of family law debts: domestic support obligations and non-domestic support obligation family law debts related to divorce or separation. Let's go over the elements in detail. First of all, domestic support obligations. These are a defined term in the Bankruptcy Code. It's in section 101.14 of the definition sections in Title 11, and there are four elements to a domestic support obligation. First of all, whom is it owed to? And the category of people that domestic support obligation can be owed to are a spouse, former spouse, child, parent of the child, or a governmental entity or agency. The second element is what kind of debt is this? The debt must be in the nature of alimony or support. Sometimes this is obvious, sometimes it's not obvious. The obvious example would be a court order ordering one party to pay support to his or her spouse or a child. The non-obvious examples might be a mortgage payment or some other payments that are supporting or maintaining an ex-spouse but may not be classified as support per se. The third element of a domestic support obligation is the formality of it, that it's capable of being established or it's been established by a contract, a court order, a decree, or an administrative proceeding. Some support obligations are determined administratively instead of in a courtroom. A state agency, for instance, social services or child support enforcement, may have an administrative proceeding for determining a support obligation. The fourth element is that the domestic support obligation may not be assigned to a non-governmental agency except or unless it's been assigned by the parent of the child, spouse, child, for purposes of collection. The second broad category of family law debts in the bankruptcy context would be all other debts related to divorce and separation that are not domestic support obligations. And the reason we have these two different categories is there are different rules regarding the dischargeability of these two different types of debts. The first rule is easy. Domestic support obligations are never dischargeable in any kind of bankruptcy. They will be owed forever. They're priority debts, and that's the kind of debt somebody cannot get rid of in bankruptcy. Now, the second category of debt, the non-domestic support obligation debts that are related to divorce or separation, are treated differently. Those are non-dischargeable in a Chapter 7 case. So if you file a liquidation bankruptcy, you can't get rid of either of those types of debts, domestic support obligations or the other divorce and separation, non-DSO family law debts. However, in a Chapter 13 adjustment of the debts of an individual with regular income, what's known as a wage earner plan bankruptcy, a spouse may discharge that second category of debt, the non-domestic support obligation debt, through the plan. And this is provided by 11 U.S.C. Title 11, Section 523A.15 and 1328. This section is still being misinterpreted by some attorneys who believe no family law debts are dischargeable in bankruptcy. That's just not true. There is a class of debts that can be discharged. So the important action that a spouse must take, either in state court or bankruptcy court, is a judicial determination that this second type of debt, what may appear to be the second type of debt, is actually a domestic support obligation and is not dischargeable in 13. Now, you should discuss with your lawyer the potential dischargeability of your family law debts in a bankruptcy.